When parties enter into an agreement, they believe that the project will be beneficial to their respective organization. There is an element of mutual trust, therefore, a contractual relationship is formed. Yet within the conditions of contract are subtle indications of the parties' reservations. Procedures for claims and dispute resolution procedures are embedded in the contract conditions to guide the parties should the situation arises. While completion of works, on the other hand, is one of the items that often leads to disagreement between parties. It is therefore important that how and when the works will be considered as complete should be clearly defined from the onset. Welcome to On Silver Screen, where learning is interesting. We are now on part 4 of our discussion about conditions of contract. If you wanted to see more videos about quantity surveying, please support this channel by pressing the like button, and feel free also to share the videos to your friends. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Now, during the first part of this discussion or this series of videos, I discussed about the general provisions and the parties to the contract. On the second part, quality assurance and control, price and payment, and time were discussed. And on the third part, we talk about the changes, risk and responsibilities, suspension and termination. In this video, I'm going to talk about the provisions of contract that deals about claims and disputes and completion of works. Let us begin. In order to better appreciate the importance of these conditions, first I will discuss about claims. We will define what is a construction claim, why is it important to have the procedures of claim in the conditions of contract. Next, we will talk about dispute. Why is it important to have a dispute resolution procedure in the conditions of contract? And what are the common alternative dispute resolution methods that are being used in construction industry? Next, we will talk about completion. We will define what is completion, and we will understand what is substantial completion and final completion. Claims and disputes. These are another term that are often used interchangeably in construction. But is there really a difference between a claim and dispute in construction? Let's find out. A claim can be defined as a demand for something considered once due, that is according to Oxford Dictionary. While Merriam-Webster Dictionary define claim as to assert in a face of possible contradiction. This means that you are aware that it is possible for the other party to find ground to resist or reject your assertion. Now, let's take a look at how claim is defined in construction. Under FIDIC Conditions of Contract 2017, a claim can be defined as a request or assertion by one party to the other party for an entitlement or relief under any of these conditions or otherwise in connection with or arising out of the contract or the execution of the works. So if you look at it, it should be noted that in this context, claim may arise due to clauses of the conditions or as an effect of work execution. Now, how does a construction claim is formed? Notwithstanding any form of contract or legal jurisdiction, the principal concept behind construction claims are similar. A claim will occur when there is a contractual or legal obligation by one party, and this contractual and legal obligation was breached. And because of this breach, it causes damage to the other party. If this happens, then you will have a claim. So this is how a claim is formed. Now, why is it important to have a claims procedure in the conditions of contract? Or in the onset, why it is important that the parties are aware how to handle claims? The claims procedure embedded in the conditions of contract should not be taken as an adversarial tool, but instead it should be viewed as a platform that provides an avenue for both parties to address the claims in a systematic way. The claims procedure allows one party to substantiate the claimed entitlement and the other party to assess the veracity of such claim. Hence, when observed properly, it allows the settlement of claim before it escalates into a dispute. Claims handling procedure embedded in the conditions of contract is a mutually beneficial tool to both parties when used properly. Now, let's take a look at the common claims handling procedures given in the conditions of contract. First, it is common to have the notification process. During this process, you have to establish the entitlement. In providing notification, it is important to identify the clause in the conditions of contract that provides you with such entitlement. You also have to take note of the time bar provisions. I have spoken briefly about the time bar provisions in part 2 of the series of videos. Please visit that video if you want to know more about time bar provisions. After serving a notification, then you have to submit the relevant document. You have to substantiate your claim. Therefore, you have to make sure that your document is sufficient. A claimant must make sure that the documents submitted are complete because the claim will only be assessed based on the submitted documents. Also, you have to take note of the time bar provisions because in some form of contract, after the relevant event had occurred or after the notification had been served, it gives you a limit or a time bar when can you submit the claim or when can you provide further substantiation to your claim. So after you miss this particular time bar, then you forfeit your entitlement for this particular claim. After the submission of documents, the assessment period will now commence. In some form of contract, when the contract administrator failed to provide assessment within the agreed period, the submission of the claimant is deemed to be approved. So be very careful and look out for these provisions when you administer a contract. The next step will be the claims resolution. It will be of the best interest of both parties that the claim will be settled, as it will save a lot of resources such as time, money, and effort. More importantly, commercial relationship will be preserved. Let us now talk about dispute. What is a dispute? A dispute can be defined as a misunderstanding between two parties, either contractual or non-contractual. This is the definition provided by Oxford Dictionary. While a dispute can also be defined as a situation where two parties differ in the assertion of their contractual rights. So here, parties to the contract has differences when it comes to interpretation of the conditions of contract. Hence, they differ in the assertion of their contractual rights. So, how does dispute in construction develop? First, when you have a claim and the parties failed to resolve this claim, let us say for a reason that the parties differ in the interpretation of their contractual rights, then this particular claim may lead to a dispute. So in order to deal with disputes which commonly arises in construction contracts, the forms of contract embedded in itself a dispute resolution procedure. So why is it important to have a dispute resolution procedure from the onset? Dispute resolution procedures in the conditions of standard forms of contracts provides an alternative avenue for the parties to settle their disputes or differences in a fast and cost-effective way compared to litigation. In the event that the parties fail to settle the dispute by themselves, let's say through negotiation, the dispute resolution procedure provided in the conditions of contract provides an avenue for a third party to step in and facilitate the settlement of dispute. Without dispute resolution provisions, the parties will be at loss on how to settle the disputes and will find a hard time to agree in any ad hoc dispute resolution available. This will leave the aggrieved party with no other choice but to resort to litigation process, which is costly and time-consuming. This often gives an unfavorable choice to the aggrieved party, especially if the cost involved to settle the dispute through litigation is far more compared to the amount in dispute. Now, what are the common alternative dispute resolution procedures available? These are mediation, expert determination, adjudication, and arbitration. Other conditions to look out for are the governing law, applicable rules, and order of precedence. Because in some form of contract, for example, you cannot proceed to arbitration if you haven't gone through mediation yet, and so on. Among these alternative dispute resolution procedures, only mediation will not provide the parties with a ruling. Instead, the mediator will try to bring the differences as close as possible and allow the parties to settle their differences amicably. I will talk more about this ADR in my future video about conflict management and alternative dispute resolution procedures. Please watch out for that video. Let us now talk about completion. When can you consider that the contract had been completed? Is it during the stage where all the works are done? Or during the stage where all the defects had been rectified? Or is it during the time when the certificate of statutory completion had been obtained? Is it during the time when the owner or the client is using the project as intended? Or is it during the period where you have complied with all the requirements of the contract? It is important that parties are clear when can they consider the works as complete, because completion is a major milestone of a project. Achieving this milestone will trigger several contractual mechanisms. Amongst others are the release of retention monies, transfer of certain risks and crystallization of certain rights, commencement of defect liability period or warranty period, whichever is applicable. It is therefore important that this event is clearly defined in the contract conditions. Completion may have a number of different meanings in a contract, depending upon the obligation. For example, in terms of the whole of the works, completion may mean completion for the purpose of handover and commencement of defects and liability period. Or it may instead mean completion including the remedy of all defects and any outstanding work sufficient for the issue of final certificate. So just try to imagine the dispute that will arise if completion is not properly defined and opposing parties to a contract has different interpretation of a single term, completion. The meaning of completion depends upon the proper interpretation of the contract and the related obligations. So it is important to understand completion from the onset. Now let's take a look at the terms that we commonly encounter, like substantial or practical completion. What does it mean? It is a stage where the project is fit to be used for its intended purpose, and the outstanding work or defects are minor or de minimis and will not substantially affect the safe use of the works or section for their intended purpose. That is what we mean when we say practical or substantial completion. Now, what is final completion? Final completion is a stage in a project closeout phase where all the works are fully completed, defects had been satisfactorily rectified, and the contractor had satisfied all contractual obligations under the contract. So that is when the contractor can declare that the project can obtain its final completion. Join me next on silver screen as we discuss about bonds and insurance. If you'd like to know more about quantity surveying, please support this channel by dropping like on the video. You may also share the video to your friends. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Thank you for watching and see you next episode.